In 2007, police conducted a routine traffic stop, ultimately arresting two individuals, the driver for DWI and the passenger for giving a false name. The officers handcuffed these two individuals, then placed them in the backseat of the squad car. They then searched the passenger compartment of the vehicle, finding a firearm later used to charge the passenger with felon in possession of a firearm. Now, at the time, under New York versus Belton, decided by the Supreme Court in 1981, this search was valid. But in 2009, while this case was still pending, the Supreme Court decided Arizona versus Gant, which cast doubt on Belton, and ultimately led the 11th Circuit to conclude that the search was unjustified. So we've seen the good faith exception in the context of a warrant that turned out to be bad, in the context of a warrant that turned out to not even exist. Here we're talking about the good faith exception in the context of reliance on a statute that is later invalidated by the Supreme Court. What happened? Let's find out. The Supreme Court decided Davis versus United States in 2011, holding that searches conducted in objective good faith reliance on binding appellate precedent are not subject to the exclusionary rule, even when that precedent is later overturned. Justice Alito, writing for the majority, gave us the narrowest articulation of the exclusionary rule to date, calling it a bitter pill that should only be swallowed as a last resort. According to the majority, it's not enough for the exclusionary rule to just have deterrent effect. That effect must also be balanced and weighed against the exclusionary rule's costs to truth and justice. But at the end of the day, the court returned to police misconduct and said that in this situation, when a police officer is relying on appellate precedent at the time, the exclusionary rule really doesn't serve to deter police misconduct. Therefore, in such situations, it simply has no place. As far as a limiting principle in this case, well, there really is none. The majority took a very narrow reading of Griffith versus Kentucky in response to the dissent's argument that the defendants should have received the benefit of an intervening change in the law. I may never fully understand Justice Alito's explanation of why Griffith doesn't apply in this case, but I suppose sometimes the best explanation is outcome.